Okay, everyone. In accordance with Open Public Meetings Act PL 1975, Chapter 231, adequate notice of this regular meeting of the Planning Board of the Township of Franklin has been provided. If everyone would please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Councilman Chase.
Here.
Mr. Howe.
Present.
Mr. Karazzi. Ms. MacGyver.
Here.
Mr. Mettler.
Here.
Mr. Manzarek. Mr. Thomas.
Here.
Ms. Rangnow.
Here.
Mr. Amola. Chairman Orsini.
Here. Okay, minutes of the regular meeting of March 16th.
Move to approve if there's no discussion.
Second.
Councilman Chase.
Yes.
Ms. MacGyver.
Yes.
Mr. Mettler.
Yes.
Mr. Thomas.
Yes.
Ms. Rangnow.
Yes.
Chairman Orsini.
Yes. No resolutions to do? Okay, so moving on, vouchers. Clark and Invignuolo, PC, June retainer, $833.33. Have a motion for that?
Motion to approve the voucher.
I'll second.
Second. I'm sorry.
Councilman Chase.
Yes.
Mr. Howe.
Yes.
MacGyver.
Yes.
Mr. Mettler.
Yes.
Mr. Thomas.
Yes.
Rangnow.
Yes.
Chairman Orsini.
Yes. The discussion for One Wood Turtle Court, Vince informs me we'll put that after the hearings, so we're into extension of time. So, we have anybody representing J. Lakshmi Vishnu LLC?
I guess they're painting the building so they can't afford air conditioning. They're probably gonna wanna do it all in one night.
To turn it on. Good evening, Catherine Kopp from the Law Office of Peter U. Lanford. I'm appearing on behalf of the applicant J. Lakshmi Vishnu. Here tonight to request a one-year extension of time on the site plan approval that we received back in 2009. My client is at this point considering changing hotel chains. Excuse me. If that happens, we'll submit a new application because there will likely be site changes involved in that. If they do not enter into an agreement with a different hotel chain, then they would like to move forward with the previously approved site plan.
Move to approve, if there's no discussion,
Is there any discussion?
move to approve the extension.
For 1 year, so how about June 1st, 2017?
I believe the extension, at this point, it expires at the end of this month.
So June
So-
30th. July 1st. July 1st.
July 1st? Okay, so from July to July of 2017. Do that.
Second.
Councilman Chase.
Yes.
Ms. MacGyver.
Yes.
Mettler.
Yes.
Mr. Thomas.
Yes.
Rangnow.
Yes.
Chairman Orsini.
Yes.
Thank you very much.
Okay. Another extension of time, 413 Somerset Street. Associates.
Good evening. Good evening, Mr. Chairman, members of the board. My name is Peter Kaiser. I'm an attorney with the firm Howard & Pape on behalf of 413 Somerset Street. This was a preliminary and final site plan application to rehab an existing use and abandon a pre-existing non-conforming use that was granted by this board back in January of 2011. The applicant spent some time putting together their outside agency approvals, ready to move forward, but our time will expire at the end of this month as well. So we're requesting a one-year extension of those approvals.
Move to approve to July 1st, 2017.
Second.
Councilman Chase.
Yes.
MacGyver.
Yes.
Mr. Mettler.
Yes.
Mr. Thomas.
Yes.
Ms. Rangnow.
Yes.
Chairman Orsini.
Yes.
Thank you very much.
Okay, so next agenda item is public comments. For general public comments not associated with any of the hearings for tonight. I have a motion to open it.
Mr. Chairman, I would move that the meeting be open to the public for the discussion of any matter which does not have its own public hearing.
Second the motion.
All in favor?
Aye.
So the meeting's open for anyone who wishes to come forward.
Mr. Chairman, seeing no one coming forward, I would move that this public hearing be closed.
Second the motion.
All in favor?
Aye.
Okay, the first of two, what should be very quick hearings, 745 Hamilton Street LLC, PLN 15-00011.
That's being carried.
What?
That matter's being carried to
Oh, so
July,
it says, I'm
July
looking at the
20th.
preliminary. Okay, so we'll hear it on July 20th.
July
No
20th.
further notice
Right.
needed. Well, this is even going to be quicker than I thought. So Hamilton Street Management LLC, carried from May 4th.
Yes, thank you very much, Mr. Chairman, members of the Planning Board, members of the public. My name is Francis P. Linus. My offices are on Clyde Road here in Somerset, New Jersey. As the board members may recall, we did conclude our presentation at the March 16th Planning Board meeting. Once again, this is an application for preliminary and final site plan approval and one variance, the impervious coverage variance that was testified to at the prior proceeding. It's to construct a four-story mixed-use structure consisting of about 25,952 square feet of retail space on the first floor and 61 bedroom and two-bedroom apartments and a studio apartment for a total of 61 units on the other floors. Again, we complied with all respects with the land development ordinance except for the impervious coverage variance. We're back here tonight because at the conclusion of the March 16th hearing, we had to supply more information regarding stormwater management to your township engineer. We did that. We submitted the stormwater management documents to your town engineer. I understand that although he doesn't have a written report, he's reviewed that and he finds it generally acceptable.
Yeah, Mr. Chairman, the applicant's been working very diligently with information with the engineering department. Our assistant township engineer and our township engineer have reviewed it, and they're, in Mr. Linus's testimony, that it's substantially in compliance. There's some minor things that they have to deal with, but it's not something that will affect the site plan, and the township engineer has no issue with the planning board at this time acting favorably on the application. They're in compliance. They've actually started their compliance on some of the other issues already. So instead of, we didn't want to give a report that had some stuff that was satisfied not, because it's still being reviewed. So we're moving forward, but we wanted to get the stormwater so the board could take action this evening.
Yeah, and at the last hearing, I think we given everything detailed on anything but the stormwater, so.
Right,
that
and
was
in
the
fact,
only-
you authorized our attorney to prepare a resolution, which is before you tonight, if you so choose to act favorably upon it.
Bob,
There was one other matter, which Vince tells me has also been satisfied, but the plans that had been in our envelope for the building were not the plans that were presented at the meeting.
right.
And we were to get copies of the revised plans.
We'll get that, and that was on us. The applicant had submitted that. If anyone wants those plans, we'll be more than happy to provide you a copy of those plans, and I'll have that tomorrow.
And just for transparency, when whatever reports are written by the township engineer on the stormwater and everything's satisfied, you just provide the board a copy
We'll do that.
of that. Just so it
Yep.
will not seem that, we approved something that we didn't see. I mean, I'm taking
Absolutely.
your oral report, for what it is, which is fine. I just want to make sure
No
that we
problem.
can get something
Yeah,
in.
and just so the board understands as well, that the plans that you did receive were substantially the same, and it's basically the 98%, it's basically the details that they had to, the second set of plans were in response to the initial set of staff comments. The building was the building, the site was the site, and it's really just a matter of a number of technical details that had changed in between one set to the next.
Well,
just-
I would consider stepping the building back in the center to be more than a minor technical detail, creating the additional outdoor space in front of the
That-
building.
yes,
That to me is a substantial change in the building.
It was, and if you recall, the applicant's architect presented that to you at the hearing and presented site plans as well as a number of exhibits, colored exhibits, so, giving you a very good idea of what's being proposed.
Yeah.
Well, that recalls the discussion that we had related to this, which was to, make sure that we get the accurate plans before we have the hearing, It is something we always ask for. Years back, I'm sure Mr. Metler remembers, we would have these fairly incomplete applications, and, we've been trying to, and I think more successful than not, put a stop to that. I noticed that Christine had sent out the electronic version of everything, which hopefully people are going to start to use or will start to use, but, yeah, let's make sure that just doesn't happen in the future. I know it wasn't anybody's fault. We had that discussion, which I won't rehash, but yeah, let's do that in the future, so we don't have this issue.
And just to complete the record, we did revisit the parking issue, and our parking plan is compliant, so we did review that issue. And we did submit, I think Betsy Dolan, you asked Betsy Dolan to prepare a supplemental traffic statement on some other numbers, and she did submit that.
Yeah, I recall your parking was compliant. The discussion was more along the lines of sort of internal issues to do with parking fee contributions and parking lots and such. It wasn't that you didn't comply. It was more that we were.
Yeah, like I said, that's one of the things, they've submitted that and other things to go toward compliance, which are being reviewed right now.
So if there's no more discussion, I'll entertain a motion to.
I'll make a motion to approve this.
Well, I think, excuse me, Madam Vice Chairman, I think you may have to open it up to the public.
Oh, right,
Yeah.
thanks.
Continuation of the hearing.
Thanks, Frank.
Yeah,
I appreciate it, yeah.
Mr. Chairman, I would move that a public hearing be held on this application.
Second the motion.
All in favor?
Aye.
Okay, this matter is open to public comment on this application.
Seeing no one coming forward on this application, I would move that its public hearing be closed.
Second the motion.
All in favor?
Aye.
Now I'll entertain a motion.
Okay, I make a motion to approve this application, and with the condition that they satisfy everything that the township engineer wants.
Yeah,
That would be a motion on the resolution? That's
No,
Oh,
you gotta
first,
Let's
approve
approve the
the case first, and then be separate motion for the resolution.
Second.
Councilman Chase,
Yes, but I really don't like being asked to approve something with absolutely nothing on paper that we've seen. We're just being told, oh, it's all right, it's all right. I mean, we don't get anything from the township engineer. We don't get revised plans. We're just taking it on faith. Okay, I'll take it on faith this time, but please.
Mr. Howe,
Yes.
Ms. MacGyver,
Yes.
Mr. Metler,
Yes.
Mr. Thomas,
Yes.
Ms. Ragnow,
Yes.
Chairman Orsini.
I agree with Ted, and yes.
Want to do the resolution?
Yes, we'll do the resolution. So, who prepared the resolution? You?
The resolution was prepared by our office. It has been given a review by the staff. It has also been given a review by the applicant's attorney. It is a document that you can say has input from everyone involved, and its final form has been reviewed and approved by our office.
And it accurately, in your opinion, reflects everything that we discussed in the first hearing and accurately reflects the stormwater changes and anything that, in other words, there's nothing in here that the applicant, there's no loopholes.
There are no loopholes, and the applicant is going to have to comply with all of the staff requirements with regard to the stormwater management.
The other thing, too, if I can note, is, as well as when the attorney prepares these resolutions, they base it on the minutes, and the minutes that you just approved, the March 16th minutes, which are not verbatim, but very detailed in nature. So if you had read through the minutes, you'll see a lot of the same language, same sentences that are in there. Two conditions that the applicant had agreed to at the hearing that you may be aware, want to be make sure that's in there. No medical laboratory facility or similar use shall be permitted to occupy the building. medical uses at the subject property shall not be permitted to operate on Saturday and/or Sunday. And that was something that was testified to at the hearing.
The other thing, Mr. Chairman, is the resolution is also based upon the attorney notes. We don't rely just upon the minutes.
Thanks.
No.
I appreciate that. So I'll,
That's only Jimmy's notes. Yeah, is that your
Not
notes?
Peter's?
Or- Yeah, or not Peter's?
No.
Let me tell you.
Whose notes is it?
Peter had a lot of notes.
yeah, Peter.
Peter does great notes, man. He does, it's like minutes.
I'll make a motion to approve the resolution.
Second?
Councilman Chase,
Yes.
Mr. Howe,
Yes.
Ms. MacGyver,
Yes.
Mr. Mettler,
Yes.
Mr. Thomas,
Yes.
Ms. Ragnow,
Yes.
Chairman Orsini.
Yes.
All right, thank you very much and have a good evening.
Hey, take care, friends. So, anybody here representing One Wood Turtle Court? Do we have anything in our packets on this?
On what?
Do we have anything in our packets on this? Not mine.
On what?
One Wood Turtle Court.
Yeah, no, I'm.
Oh, you're doing it.
I'm doing
Oh,
this.
okay.
I'm doing this.
At least we got one Hamilton Street project out of the way. Hopefully we get the other one soon.
One Wood Turtle Court is part of the subdivision that was approved years ago.
Can you use the mic, please?
Yeah.
Is he sworn in at the beginning of the year?
Yes.
Oh, okay. Otherwise, that does his job.
Feel free to.
Yeah, that should
The
be.
Hamilton Business District had to do with it.
Let's see.
Vince, were you sworn in at the beginning of the year? Oh, okay, good. I don't have
One
to
of you
re-swear you.
swore, yeah.
Okay.
You were,
Couldn't help it. Thank you to the answer.
part of a subdivision that was approved years ago. And several years ago, the applicant came in, put a pool in.
So Vince, hold on a second. Give us some context as to where this might be. I mean, I could GPS it on my phone, but just,
Location-wise.
yeah.
It's off Butler Road.
Oh, okay.
It's on the corner of Butler and Wood Turtle, is that right? So it's a
Yeah.
corner lot?
Okay.
As part of the major subdivision, there were various areas and almost all the properties that had conservation easements. Most of them didn't have anything to do with wetlands or anything else, it just is to have open space they couldn't use. What happened here is they put a pool in, and subsequent to that, just in the last year, they got an approval from us to put a solar array in. When it was reviewed, you see this little squiggly line here that said conservation easement, but there was no hard line. So when we reviewed it, we approved it. Subsequent to that, when they came in and got their as-built, the new surveyor put the hard line in, and it was determined that their fence and some of the solar array and pergola were within the conservation easement. So there's one of two things we can do. We can either make them remove all this outside the easement, or I think I'll let our attorney explain what his recommendation would be if we want to allow them to not have to move the different improvements.
The less draconian alternative, all right, would be to first identify if the area that's been intruded upon has any special resource value. And I've spoken to Vince, and Vince says to me, no, it's just a general conservation area. It's not in the area of any wetlands. That being the case, I think to protect the township's interest, you consider that, all right, we do a calculation of the number of square feet that's been intruded upon, whatever it is, 300, 400 square feet, all right? And you then say to the property owner, fine, you've intruded on this 400 square feet, give us 400 square feet somewhere else contiguous on your property. That would be, I think, a solution for you to consider.
It's almost like a like DEP's wetlands mitigation where they do.
Has the-
Exactly, except we're not going to ask them to do 2 for 1.
Has the owner been approached
I
on
know.
that, and are they agreeable?
Exactly.
The-
If you want to do 2 for 1, go for it.
The owner, I spoke to the owner, and I told him I was coming this evening to make the board aware of it, and honestly, it's what you want. Because You could, in, as the word being draconian, and you could tell him he's got to remove everything from the easement. So anything is better than having to remove everything from the easement. So he's,
But
he has to.
is the owner agreeable?
Well, he
Because
doesn't
this-
really have a choice.
Well,
I mean, honestly, he doesn't, because the only choice he has, if he doesn't agree to that, is to remove everything, because it's in an area that we have an easement that's filed that he's not supposed to build in.
right.
So,
Does the lot have the ability to do what we would ask?
yes, I mean, he has this whole area here,
Well, let
and
me,
in
let
here.
me offer a suggestion on that. I mean, there is a certain area that's been disturbed. I think it had trees on it. I think they could pretty easily make an estimate of how many trees were removed based on the existing forest cover, and they'd have to replace that same number somewhere else on the property.
In addition to giving us the
Right.
land area.
Yeah?
Meaning in the form of a bigger conservation easement.
Yeah.
Okay.
In other words, give us back what they disturbed in another location and do the trees. I
I
didn't
mean,
realize.
they got plenty of room here. They got this whole area here and here, you know.
And one thing, too, to the degree it matters, in a few minutes, we're going to talk about a draft stream corridor ordinance. And the pink line that you see there is an estimate of where the stream is located. And then you can see kind of a line parallel to it, and that's a line 150 feet away from that stream, because we wanted to see, well, we're going to talk about the stream corridor right after this. You know, would this have impacted that, that ordinance? And you could see kind of the tiny little triangular area, Vince, that goes within the 150 feet. So even though, just so you understand, that they did disturb within the conservation easement, but as far as your stream corridor ordinance, the disturbance is significantly less. So they basically just barely touch it.
And if you like that alternative, then the owner's going to have to amend and record a new easement document.
And that he's fully aware of, because I told him, you know, the board could do one of two things, and the second one would be, you know, redoing the easement, so he's fully aware of that.
Yeah, I mean, it doesn't seem as though the applicant was willfully, you know, probably with the conservation line was nebulous and mistakes were made. So, yeah, it would seem logical that if we can get the area back and get it restored to, you know, tree it, that would be a good solution.
All right.
Any other opinions? Anybody think differently than that? Want me to rip it out? Okay. Not draconian? Ted?
Oh, I was just wanted to say, I hope this doesn't happen again. That is, that we get a better check on what the limits of the conservation easement are.
I would say that engineering is, the next time that it happens and there's a little squiggly line, they'll check the old subdivision deed to make sure that we don't make an error like that.
I know that engineering has produced a complete inventory of conservation easements, partly because, well, mainly because it's a Sustainable Jersey action. And there are, in fact, 1,661 conservation easements recorded. So I can see nobody will have them all in mind.
Yeah, this was just a perfect storm. Almost all of the surveys that we get actually have the line. This one didn't, and we're both fully aware. When I see one that doesn't have it, because I look at it first, I will make sure that I get a survey that has that, and I will point that out to them even before it gets, and if I happen to miss it, engineering now knows that, you know, to take that extra look.
Do you need anything from us in terms of any memorialization of this, or is this general just halt?
What do you think?
I don't think we need to take any positive action now, because what I'd like to have happen is get a new meets and bounds description, show us on the map where it's going to be located,
Okay.
calculate the number of trees lost, get a an agreement that they're going to give us the same number of replacement trees, put all that before you, all right, and then at that point, it can be listed as a discussion item, and you could vote on a motion.
Sounds good to me.
Works good for me.
Okay, so last item of the evening is stream corridor ordinance. And if I wouldn't miss my guess, this is probably another thing on Ted's green team list. But
Actually, I don't think it's not a green team item. I think this
he's
is
on
a.
fire. I mean, there's
this
been
is a-
something every meeting since it started.
This is a wish list that I think Councilman Chase, as well as the Environmental Commission, have wanted to take care of for a number of years.
Yeah, I think our stream corridor ordinance is big enough to drive a truck through, so this should hopefully do better. So you take it away, whoever's going to talk about it.
Go over, do you want me to go over?
Well, I'd just like to say that while I set this in motion, particularly because the stream corridor ordinance that we had on file, that was in our land use ordinance, had an enormous loophole in that first it said 300 feet from streams for a buffer, and then it said, but if any wetlands have been determined along the stream, then the buffer is only 50 feet from the edge of the wetlands, which meant, in effect, it was always only about 50 feet from a stream. So we wanted to eliminate that. But Mark looked at the ordinance and concluded that it was unduly complicated and difficult for anyone to understand, and he could write a better one. So he has spent his time very well in writing a better one. And we reduced the corridor along most streams to 150 feet, although it's still 300 feet from the Millstone River, the DNR Canal, and C1 streams designated by the state, which means 6 Mile Run and its tributaries. So the existing state rule includes the upstream tributaries along with the C1 stream, but as a result of a good deal of commentary from Arnie Schmidt of the Environmental Commission, Mark has also put this into our ordinance to ensure that these streams are protected. 6 Mile Run itself, of course, is surrounded by state lands. It's not under any threat, but the Franklin Park Brook, otherwise known as 9 Mile Run, is a tributary which in many places really does deserve some protection of this nature.
I think that the main gist of the ordinance is, when we sat down and went over this with the Environmental Commission, it was basically, what are we really trying to protect? It's not necessarily that every area within 300 feet of some of these streams or 150 feet needs to be protected. In fact, there are a good number of areas within proximity to streams that have already been disturbed. There are people's backyards. There are Rutgers Plaza, I'll use that as an example in a few minutes, that has already been paved over and developed. So we kind of looked at it and like, well, what do we really want this ordinance to do? Well, we wanted to prohibit further expansion or additional disturbance in areas that are currently undisturbed. So again, to use Rutgers Plaza as an example, because it's a site that I think we've all been to, that is a stream running along the back of it. Certainly a good portion of that site is within 150 feet of that stream. The fact, that fact would make us look at that a little bit closer if there's some work that's being done there. But if they're going to do some work in an area that's already been disturbed, if they're going to, I'll make something up, they're going to add a loading dock to the rear of the building in an area that's already paved. Well, that's going to need site plan approval, it'd be subject to stormwater and other development regulations. This ordinance wouldn't come into play because it's already disturbed. But if they're going to regrade the slope adjacent to the stream, put a big retaining wall in, take a bunch of trees down adjacent to that stream, well, that'd be prohibited, and they would have to seek a waiver, and presumably it would be very hard for them depending on, how the board deals with that. But the intent would be, that would be very tough for them to do. We would want them to keep disturbance to areas that have already been disturbed. Similarly, there are a handful, not too many, but there are some streams that run through neighborhoods. Similar thing would apply. If a homeowner wants to put a shed in their backyard, and they have a stream in the backyard, well, they can put it anywhere that's already been, anywhere on their grass, obviously subject to zoning, setbacks, and stuff like that. But the ordinance would not come into play if it's already been disturbed, it's already been graded. But again, there's that vegetated slope next to the stream, and they're going to regrade it and take trees down adjacent to a stream. Well, that would be prohibited, and they'd have to prove that would be absolutely necessary, and they can't do it. They can't. They've done everything else to avoid that disturbance. And then we've also added what's not in here now, some review criteria, which is kind of important. So when you have something that comes before you, you know what you're supposed to review it against. I had a chance. Cecilia MacGyver had a chance to review it and had a few comments. I'd like to go over some of her suggestions. On page 2, objective B, she had some good comments about kind of what that, and this is the existing language. We didn't change that, but she's right. I think it just needs to be rewritten to basically say that the intent is that when developers come in to develop new properties, subdivision site plans, that the intent is that to the maximum degree practicable, they should stay outside of these stream corridor areas. So outside of 300 feet away from the C1 and 150 feet from the other streams, and they should do everything practical in their design to avoid those areas. And I think that is a good suggestion. And the other suggestion was on section, the pages aren't numbered, but it's section 112, 229-2. The language is a little confusing. A plan indicating the disposition of any fill materials to be deposited by the grant. What this is basically asking for is a grading plan. So I think this needs to be worded a little bit more simply. She asked me, what does disposition mean? And I couldn't answer the question. But the intent is it's a grading plan. So I would suggest those two changes to what's been presented to you. Oh, lastly, it has been reviewed by Environmental Commission, and the Council's Land Use Committee has also reviewed it, and they were satisfied with the draft.
So what would we do now? Simply make if we move this, we'd move it to council, and then they would
send it back to you.
It'll get introduced, and then you'll send it back to say it's in conformance with the master plan.
Yeah. Any other comments from anyone regarding this?
No, but do we have to do a formal?
You should do something, yeah, I mean, you can do it by affirmation, you don't have to take a roll call vote, but there should be a recommendation to send it to council.
I would move that we send this to council with the amendments discussed brought forward by Ms. MacGyver and discussed by our planner.
Second the motion.
All in favor?
Aye.
Opposed? Abstain? No, motion carries.
Mr. Chairman, we probably will not now meet until the end of July. We don't have anything as of now. We'll make sure, next week that something crazy doesn't happen, that we have to meet in 2 weeks. And if you remember, you did not schedule a meeting after the 4th of July, so the next meeting, I think, would be July 20th, unless something crazy happens in the next week. So
Okay,
that's the way it looks. You'll get the notice next week.
all right. Well, what about the other Hamilton Street, the 745, or what is it?
745, we carried them to July 20th. They've been submitting stuff to engineering, and they just did their geotech last week, and they have not submitted that, so without having the geotech to back up everything else, as Carl will tell you, there's no way for us to make a determination. We've seen some of this stuff, so we're pretty confident, but until we get the geotech, there's no way for our engineer to be able to opine and say, yes. They're just a little bit behind, but they have been working with us diligently, they're just a little slower.
Okay, so that would potentially be the next meeting.
The July 20th, that's when we carry to it, assuming they get us and we have time to take a look. And I will make sure, as Councilman Chase pointed out, that we have something in writing from the township engineer so that you're satisfied about it.
Okay, sounds good. Looks like we have some time off.
They have till July 20, they should really have everything in order.
I hope so. We've been working with them. Both of them have been working diligently. They're just, sometimes things happen that take a little bit longer than they expect to, so.
Okay, motion,
Motion to adjourn?
I'll second. All in favor?